Welcome back, everybody. This is Haz'el Inspirations, back with Mr. Ford here, and we are continuing our conversation about the legal representation while incarcerated and their reentry process back into society. We've highlighted a lot of areas, and I think that we were going to go into about the legal services, legal aid services.
Mm-hmm.
And if we can touch a little bit about expungement and legal advice.
Okay. So the legal services for people who are on the way into prison.
Yeah.
All right. Let's just deal with in the jail.
Okay.
I mean, I can go step by step.
Yes.
So I think we kind of already addressed the type of mindset that you have to be in the preparation stage for the criminal justice process or prosecution. You have to be kind of specific. You have to be informed. You have to take time to educate yourself on the process, what you should say, what you shouldn't say, what kind of lawyer you should look for,
right?
What you should ask that lawyer to do for you instead of just, asking your lawyer to fix your situation. Be involved in the process of understanding.
And before you sign anything, you need to read it. Yeah. And if you don't understand it, don't sign it.
Don't sign it. Don't sign it. If someone's making you sign it, then they're signing it under threat, what we call threat, duress, and coercion. So if you could put TDC on your paperwork, which means the same thing. And if there are terms in that paper that you're signing, because usually it's contractual. All the courts are really contract courts. They're enforcing contracts. And that's something that our people really need to understand is, a lot of these people who run major corporations, they don't sign anything. They have someone else sign it because they don't want to sign it.
Right.
Because your signature is valuable. And if you don't understand that, they will show you later on down the process how valuable your signature was, because they will say, did you sign this? Okay, so we're going to hold you to the terms and conditions of this paper. And their famous statement is, ignorance of the law is no excuse.
Right.
So, just because you say, well, I didn't know, they're going to say, well, ignorance of the law is no excuse. So you should have known as much in-depth knowledge as you could on contract law, because that's what we're going to hold you to. So be careful of what you're signing. Be careful of all these fast papers coming in front of you. If it's not beneficial to you, don't sign it. If someone's making you sign it, or you could write an X, or you don't have to write your name, or you could write TDC, threat, duress, or coercion. So that means on the second end, when they go to enforce that, they cannot enforce it because it's void. You cannot enter into any kind of contract in that manner. It cannot be involuntary, unknowing, or unintelligent.
Okay.
Meaning, involuntary is you some kind of way you made me do it. It was not what I volunteered to do. You twisted my arm, or you held a gun to my head, or you disclosed to me some kind of penalties or punishments if I don't sign it. If it's unknowing, it means I don't even understand what it is, or you misrepresented what it was.
Right.
If it's unintelligent, it means I don't understand the law. I might read it all day, but if I don't have the lawyer speak, or the jurisdiction, then I don't understand what it's saying anyways. I don't know if it's serving as what they call like an adhesion contract, where it's bringing other things into the contracts are supposed to be four corners on that paper. Everything is enclosed in there, all terms and conditions, and everything is understood by both parties. And that you both sat down and put terms and conditions on there that benefits or each party. Anything outside of that is unbalanced. It's lopsided. It's punitive. And you should not engage in contracts in that way. And that's how all the contracts that usually you're dealing with in the criminal justice process, they're on what they call boilerplate forms. And in certain cases, the court speaks very negatively against so-called boilerplate forms, which just means this is a form that it's one form fits all people, and all you got to do is write your name in here and your date of birth and this. But in that way, that's not two people sitting down and writing a contract out. And then so we can negotiate the terms and conditions of this and make sure we both understand what it is. They've already got it pre-drawn up with their knowledge of what every single term means, and you don't know anything. So be careful of what you're signing, because every single thing, like they say, every single thing that you say or do will be used against you in the court of law. They don't say every single thing you say or do we will consider if that was bad.
Correct.
They say every single thing you say or do will be used against you in the court of law. So that means whether you signed it or if you didn't sign it.
Right.
Whether you spoke or you didn't speak.
Okay, now let me ask you a question about that. The paperwork that an individual signs when they're in court, these documents that they are supposed to outline with their attorney, public defender, whomever, are these part of their discovery paperwork when they get it?
They could be
or part of separate paperwork.
Well, discovery is its own process. It's like basically discovery is something that they have in Virginia. So that's not the same thing. It holds, and these are specifics that I'm dealing with right now. Now we're getting into something that's more specific. So discovery is almost the same as what we say Brady material is. Brady material is things that are inculpatory or exculpatory, meaning it inculpates you, it means that you committed the crime, or it exculpates you, it means that you didn't do it.
Okay.
And that information is so-called material, and it's supposed to be disclosed by the prosecution to the defense. So anything that is inculpatory that could be used to incriminate you, or exculpatory that means it could be used to get you off, is supposed to be given to you. Discovery under Virginia laws is a separate process. It's in line with that, but certain things are allowed to be disclosed during discovery, and there's a lot of little rules and ways that. So they in Virginia they have what they call trial by ambush. So you might go into court and you might have put in the discovery, and the way that it was disclosed during that state discovery process might not be consistent with the Brady process all the way. And so you're walking into court with not everything that you thought you were going to get, because the way that your lawyer requested it was through discovery and not through a Brady disclosure. So you're getting a limited amount of information. It might come late. It might come some other period of time. And that's how people have trials by ambush, because you're walking into court. You didn't know there was a forensic analysis. You didn't know this statement existed. But so you got to, those are like those, they seem like just small particulars or whatever, but they're really very important and could be very detrimental. It could cost you 22 years in prison.
Now, when you're assisting someone in a law library, I've seen a lot of individuals have boxes of their legal paperwork. Are you filtering through that paperwork, and is everything outlined? Is everything in that box that you would need to see that they signed documents that they didn't understand? I'm just trying to get a clear understanding, because if you're in court and you're signing documents and you're not reading the terms and conditions, and then later on down the line, 5 years down the line, you don't remember why you signed that document. It wasn't explained to you, or this wasn't, what you thought it was supposed to be.
Yeah, everything. It's like say you take a hoarder case. You saw the show Hoarders or whatever. Yeah. Well, you go into a house and you have coffee pot, bathtub, toaster oven. You have all this stuff, a fax machine, all jammed into the same place. But somebody got to come in there and sort it all out.
Right.
Because otherwise it's just a bunch of junk. You don't know what you have. You don't know the value of anything. So when people come in, and a lot of times people don't know anything about law. They just know I got a box of stuff. Right. I was taken into the police custody by gunpoint, SWAT team or whatever, thrown in here, and maybe somebody gave me a box of stuff. Maybe this is all the stuff I need. Maybe it's half the stuff I need. So I don't know the importance of it. So you have to become and get organized and get educated about what is in this box. So once you start sorting through it, you start putting things in order by date. That's the most important thing. Always put everything in order by date. And when you do that, now you're seeing the process for how you came into incarceration. Because now you're like, okay, right. So right here, when I signed this, that led to this. And then this is when they had the hearing based on that. And this is when, and a lot of times guys come into the law library and their paper is all papers are all over the place. So I have to first
organize.
We're gonna get that in order by date first, so I can see.
Right.
And then you could tell me what you want. You might not know what happened because you have a limited comprehension of the process in the first place. So I have to look at the paperwork and see, okay, this is when your first hearing, or this is when they arrested you. This is what that witness said. This is when the first hearing was. This is what your bail people said. This is when your lawyer got on your case. This is when your lawyer signed to get off your case. This is when they assigned you another lawyer. But in between that time, that's when another witness came forward and said something. And that's when this other investigation. So you have to build the timeline so you can understand how this person came into custody. And usually that's not done until you get into the prison. Like the so-called jailhouse lawyers, we don't have a problem with that name. We do so much work on the post-conviction side because we have the whole case. Your lawyer in the beginning, he doesn't have the whole case like we have it in the second instance sometimes. And now sometimes part of our problem is that some of the information that we need is withheld, and it was necessary even for your conviction, or for us to try to address your conviction and overturn something or decrease your sentence or something like that. It's missing from your case, but it might have been read into the record as if it existed, and it never existed. So now, or there was a problem with whatever it was. So there's so much. The main thing I can say right here, without spinning people in too many different directions, is put yourself in line to be educated and sit yourself down. There's so much drama and conflict when you're being arrested and you're trying to hang on to all the stuff in life that you have no control over. You're trying to do everything you can to explain your situation to a lawyer, or not be convicted or something. You're like a person drowning in the water. You're making tons of mistakes because you don't know what you're supposed to do and what the gravity of the words, your statements, your actions, you just don't know. Not until you get, and then the jail is a crazy place. So the jail is hardly the place to fight a case unless you have been through that before many times and you know what you're doing. The jail is hardly the place to do it, because the way that the jail is set up, and it is not conducive to people trying to fight cases. You might get, this is where, now once you're going from out in society and you're going inside, you're talking about your access to legal materials, and you have a constitutional right to that. You have a constitutional right to adequate access to legal materials and the courts. So now when you get into the jail, they might have a law library, but it might be one guy, one computer, and you don't know what your access will be. So it might be a institutional attorney. It might be a good law library. It might be a one computer law library with a guy that doesn't know anything. It might be a guy that knows a lot, but he doesn't have time to deal with your case. So a lot of times you won't get to a good law library until you get into the Department of Corrections, because the jail is not, they don't run the jail for that. So, and really they are supposed to, because that's why you're in the jail. It's not, they treat the law library in the jail as if it is a privilege, but it's why you are in the jail. The law. So why deprive a person of access to the law, but hold him to the law and use the full weight of the legal process against them, but don't give them access to the law to see if that's even right, to see if what is even is happening is correct.
Now, there's a time limit, not to cut you off, there's a time limit for filing too certain documents, correct?
There's constant time limits. It's not one, they are repeated. They are continuous. There are so many different time limits, from the time they put the handcuffs on you through the time you walk out of the prison and beyond, that you have to file, depending on what you're filing. Just like if pre-trial stuff, there's time limits, and you have to be aware of those things. Pre-trial motions, you have to be aware of post-trial motions, like motions that you can file after the verdict motion, which is before your appeal process. So the court in Virginia, and most states, they lose jurisdiction after a certain amount of days. What that means is, and I'm getting into a complex situation again, but what that means is, let me try to break this down. If you, when you are arrested by, say, the county, okay, all right, Virginia is a corporation inside of a corporation.
Okay.
So the United States is a corporation. It's a corporate government, a corporation. They have sub corporations, basically,
okay,
which are the states. The states are supposed to be sovereign corporations, freestanding, and then they have all come together with a federal government, and they have made a larger corporation. So they're supposed to maintain a sense of sovereignty and really be high in that level of the corporation, but there's a balance in that. But now you have the federal corporation, you have the state corporation, and the state corporations issue out basically sub corporations.
Okay.
So let's just say the counties are sub corporations. That's what they were. They were corporate courts at first before they were changed to circuit courts. They were they're corporate courts. So you have, the counties are a sub corporation, a sub business.
Okay.
And then you have inside counties, a lot of times you have towns and cities, and those are sub corporations of the county.
Okay.
So now when you're dealing with the courts, right, if you're going through like the felony criminal process where your case, you have your general district court, which is where your case first starts when you come into the jail, and you go past the magistrate and they assign your case to the preliminaries, and you're going to the general district, and they're trying to see if they have enough probable cause to send your case upstairs, basically to the circuit court, which used to be called the corporation court. It was the court for that corporation, that county corporation. Okay, now they changed it to circuit courts. But so that county corporation has jurisdiction over your case for a certain amount of time. Once that 21 days is over with after your conviction, they lose jurisdiction, and your case is now held in the larger corporation of the state of Virginia. So where before your case was handled by the sub corporation lawyer, which is the Commonwealth attorney, after you have done had your 21 days to file whatever you had to file, your case is now put into the attorney general's hand, the lawyer for the state. So you have the lawyer for the county, which is the Commonwealth attorney, and then it passes your case over to the lawyer for the state. So now they take your physical and they put you from the county jail into the state jail. So now that's why once you go into the state jail, you have to go through a totally different legal process to have your case heard, because that court no longer has jurisdiction. Your jurisdiction is passed to the state.
Right.
And
in transit, you could have filed in the county and waiting to hear, not knowing that they're going to move you to the state, and then you have to start the whole process over again, right?
Well, we have done so much fighting in the system because of those things like that, and prisoner advocates and things like that. So a common problem that was happening was, say you were in the jail and you had filed a post-conviction or after judgment motion. You made a motion to set aside the judgment, or you want a reconsideration, something that you can file within the 21 days. Now, the jailer, the sheriff in the jail, he might look at his population and say it's overcrowded in here, and I got to send people down the road. And so you're out of here. But my case is pending.
Right. Oh, they don't care about that, right?
No, they don't. They're like on two different, totally different systems on purpose. Yeah. So they take the people and they send them into the VDOC, and then that physical transfer actually causes the circuit court to lose jurisdiction over your post-conviction motion or after trial motion. So now the circuit court, I don't care if they were going to give you relief, they no longer have jurisdiction. So over the years of us fighting that, because some people, they might have been in the jail and the circuit court said, well, this is what we're going to do. I'm going to give you like 5 years, but what I want you to do is take this alcohol class or take this victim impact class or something like that, and I'm gonna call you back within 90 days. The class is 60 days or something like that. I'm gonna call you back in 90 days, give you time to take the class, give you time to pass the class. I want a good note from the teacher or whatever, and say that you did a good job. And I'm gonna cut your sentence from 5 years down to 1 year or time served or whatever. I'm gonna let you go. Well, in that period, that person could get transferred
to the state.
So now he has to do the 5 years. So now he might have entered into the guilty plea because of that contingency. So now that calls into question the entire process. Like, was this a trick? Was that a scam? Did you get me to sign the guilty plea just to get me to sign it, knowing this guy was going to send me down the road when nobody put a protection on my case? You didn't tell the sheriff. You didn't give him a letter and say, do not move this guy under any circumstances. He is supposed to complete this class. So over the process of those things happening, which there's so much stuff that happens behind those walls that people are just not aware of. But so now a person comes into the system, and now they come to the law library and they're saying, hey, I just got sent in here. I was actually only supposed to do time served if I took this class. I was halfway through it and they sent me down here. So now we have to go through this process of file it back to the circuit court judge and see if he could regain jurisdiction over it. And a lot of times they couldn't do it. So through that work, bringing that issue to light, they did finally expand the time that you could file a post after the verdict motion, or that the court could rule on it, but they only gave them 60 days. So it's still like not a lot of time. And there's so much game with that that I mean, I can just go on and on. It's so much game with each part of this that you really got to learn how to guard yourself or protect yourself at all times.
Right. So it's an awareness to yourself, and I guess to family members of those that, you know, are in this predicament, unfortunately. Wow. I'm learning a lot.
Yeah.
I want to encourage everybody, our listeners, to, you know, not only be knowledgeable, like you said, you have to be knowledgeable about the reentry services, about resources, about, you know, educating yourself. But I want you to give them a word of advice, you know, to take with them, because when we come back, I want to talk about we didn't highlight about expungement. And I want to talk a little bit more about understanding our rights.
Right.
So, but for our listeners, as we close for today, if you could share a word, mentoring word for them, and letting them know that, you know, they're not alone. And I just want to say, if you would like to reach Mr. Ford, please go to Haz'el Inspirations website. You can give me a call or you can email, and I would get the information to him. If you have a loved one that is in the system and you would like to see how he can give you some guidance as far as legal advice, now he may have a fee, and that would be totally up to you and Mr. Ford. But just giving somebody advice about what path to go down, I think that that's something that
like if anything, I wouldn't charge anything, because we don't do that.
Okay.
But yeah, this is it's just all help and assistance. Like, I mean, a lot of this is just trying to comprehend.
Okay.
You're trying to understand yourself. You're trying to understand. There's no quick fix.
Right.
Give yourself time. Just like I had to give myself time coming out here, you got to give yourself time going in there, because it's another world. It's a different world. Yeah. And put yourself in the seat of learning. You know, don't be afraid to learn, and don't be afraid to ask questions, and be dedicated to whatever it is that you're learning. You know, you got to take time to study, and you got to take time to get outside and clear your brain, because the legal process is frustrating.
It's very
so
frustrating.
Much that you have to know. It's a labyrinth. It is meant to be like a spider's web. And, you know, the best thing that we can all do is try your best not to come into contact with it.
Thank you.
Try your best not to come into contact with it. It's not about beating the law or whatever, but now, not just to not come in contact with it, but we really have to do a lot more in regard to learning who we are, learning our history, learning what the government is, learning our status in relation to ourselves, each other, and the government, and learn what they have jurisdiction over.
Right.
Those are key. You know what I'm saying? If you don't know those fundamentals, the rest is going to be problematic. So, and that, some of that, like, we will cover some of those things when we talk about the knowledge that you receive from the Moore Science Temple.
Yes.
And about our culture, our heritage, who we are.
And I can't wait to get into that segment with you. Yeah. I think that's going to be a beautiful outlining foundation as to where we started with these episodes to where we're going. And I think that's going to be a beautiful highlight. I'm waiting. I saved the best for last, as they say. So thank you, everybody. Until next time, enjoy, be blessed, and don't forget to stay connected with your loved one if they're in the system. Don't forget about them. They need to be guided. They need to be mentored to. They need strength. And family and friends are the ones that help support. Okay, take care, everybody.